Good morning to both of you. The only case by a video argument today is Kimberly K. Bender versus Summa Rehab Hospital, LLC, and Stephanie B. Cloud, administrator of the BWC. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time, please let me know when you get started this morning, because I am keeping the clock. Please don't use the names of any victims or minors. I don't think it's relevant to this case, but we like to remind everyone as we are broadcasting live stream and this oral argument is being recorded and posted on the court's YouTube channel. We have read the briefs and we are ready to proceed when you are. Counsel for the appellant.
Thank you. Good morning again, Your Honors, and may it please the court. For the record, I am Tim Marcovi. I represent the defendant appellant, Summa Rehab Hospital. At this time, I'd like to request a reservation of 4 minutes for rebuttal. Thank you, Your Honor. Your Honors, there's two questions presented by this appeal, and I think they are both answered very simply by reference to the record and to the settled case law. There is, however, a preliminary question that I would like to bring to the court's attention. And that is, there was a motion to vacate the judgment, which is the reason for this appeal, the October 4th, 2020 judgment. That motion to vacate was filed in the trial court, and I think it was filed on October 19th, and was pending when the time to take this appeal was about to run. So we had to file the appeal. We did file a motion for a limited remand to the trial court to resolve that, which would, depending on how it was resolved, it would obviate this appeal. That motion for limited remand was filed on November 30th, 2020. It was unopposed and it remains unruled upon by the court. I just want to bring that to the court's attention before I proceed further with the argument.
Thank you.
Yes, Your Honor. The first question presented by this appeal is whether the trial court committed reversible error when it vacated its prior judgments of dismissal with prejudice. Those were in May and June of 2020. In its October 4th, 2020 judgment entry, without any agreement of the parties and without any motion to vacate filed under Civil Rule 60. Clearly, there was reversible error committed there. I think that at the time the judgment entry was entered on October 4th, the transcript of the October 2nd oral hearing had not yet been prepared or filed, wasn't before the judge. Once we filed that, I think a review of that transcript is clear that there was no agreement of all the parties to vacate the judgments entered in May and June of 2020. The record is also absolutely clear that no 60B motion was filed by any party to vacate the May and June final judgments. If you look at the transcript of the docket, you will look in vain for any such motion having been filed. The law is equally clear, Your Honor. Rice versus Bethel, that's a Summit County decision, and the Cuyahoga County decision in Dickerson versus the Cuyahoga Metropolitan Housing Authority make clear that a trial court has no legal power to vacate a final judgment sua sponte, as occurred in this case. And that to do so is an abuse of discretion and reversible error. Under both Dickerson and Rice, we ask that the judgment of October 4th, 2020 be reversed and vacated. The second point.
Before you get to your second point, I have two questions.
Yes, Your Honor.
Regarding the issue that you raised preliminarily, the motion to vacate the judgment was filed October 19th, correct?
Yes, Your Honor.
That was at the trial court?
Yes, this is really confusing, so let me be clear. This was our motion, Summa's motion, to vacate the October 4th judgment, which in turn vacated the final judgments.
Okay, so Summa filed Summa filed a motion to vacate the judgment that is the issue of this appeal, correct?
Yes, that is
All
correct, Your
right.
Honor.
And that was not ruled upon yet, correct?
Correct. I think the time just about ran out
Gotcha.
when we had to file our appeal because a Rule 60 motion doesn't stay the time for filing an appeal. So
Exactly.
we filed it, but I understand that the procedure created by this court in the Majnerick case to allow for a limited remand exists and has been, well, like I said, it was created by this court. It's been approved by the Supreme Court of Ohio, and it's out there. And our motion filed in this court for a limited remand remains pending and unopposed.
All right.
Okay.
So my question then about putting all that aside just for a minute, the order itself that's being appealed, as I read it, what I read of this order as it stands is it says it will be stayed. And so I'm guessing after the judge did whatever the judge did, with or without jurisdiction, we have a stayed case here. How is that a final appealable order?
It's a final appealable order, Your Honor, because an order vacating a final judgment is by definition under 250502 a final appealable order. That's the first part of this. What was stayed in the October 4th order was simply any further proceedings in the trial court case. But before you got there, the trial court, the judge acting sua sponte resurrected the done, finished, and over with trial court case.
But it was a conditional stay, wasn't it? If plaintiff fails to file her complaint, then it's right back on.
It was. It is not part of this record, Your Honor, but it is my understanding that they have,
in fact, hit the point right on the button. It's not part of the record. Yeah.
That they did file their case and separately, and nothing further was done by the trial court then thereafter.
Okay, thank you. Go ahead.
Yes. Your Honors, the second point is the reversible error committed when the trial court did not simply grant the motion to enforce the settlement agreement. We're relying on pretty solidly on the Tarosi Bonding Company versus Mitchell case. This is a case that's almost on all fours with the case at bar. There, an exchange of emails by attorneys representing the parties came to the essential elements of a contract of settlement. And thereafter, one of the parties said, "No, I don't want to settle." This is precisely what happened here. In fact, this case involves a more solid argument for enforcing the settlement agreement. In this case, not only were the essential elements of the contract of settlement settled, but every jot and tittle, every minor detail was agreed to. The exchange of emails dated June 12th, 2020, which are in the record, clearly show that the plaintiff received and carefully reviewed the settlement agreement, wanted two small changes made. Summa agreed to those changes, and then the response back from plaintiff's attorney was, quote, "These revisions look good on our end." I would be hard pressed to find language that would be more definitive of an agreement. The agreements, of course, are also part of the record, Your Honor. And what they demonstrate here is that the trial court did err when it failed to enforce the settlement agreement. That settlement agreement should therefore be enforced. And the law favors settlements, the law favors enforcement of contracts, and the fact that someone enters a contract and thereafter just says, "No, I don't wanna," I don't think is a legal grounds or a legal basis for failing to carry through the settlement agreement. We'd ask, therefore, Your Honors, that that decision also be reversed and this case be remanded to the trial court with an order that it enter an order enforcing the settlement agreement and hold a hearing on the issue of whether or not Summa is entitled to attorney's fees for having to file a motion to enforce. If there are any other questions, Your Honor, I'm happy to answer them. Otherwise, thank you, Your Honors.
Thank you. You'll have a full 5 minutes for rebuttal.
Thank you.
Counsel for the appellee.
Thank you, Your Honors. May it please the court. With respect to the initial issue Mr. Markovi brought up, that motion to vacate that he filed after the October 4th vacating, we did file a response. So I pulled the docket up. We filed our response and the court issued an order regarding that issue. So unless I'm wrong, which I'm just looking at the docket of the case, it looks like our response, our brief in opposition was filed and the court issued an order dated the same day. I think those were both filed October 29th of 2020, as I see it, at least.
You're talking about the trial court.
I am.
Yeah, I think he's talking about the motion for limited remand that they filed on, it
Okay.
looks like November 30th went unanswered.
In the appellate court.
Correct.
Okay, understood. I wanted to make sure I wasn't sure. I guess that was the issue. So with respect to the issues on the appeal, I think I'll address them in reverse order. I mean, whether or not there was a meeting of the minds, and obviously the court has those emails that have been made part of the record with Attorney Kuzma. If you look at those, he does say those specific revisions, one regarding no rehire provision if she were to be, essentially if Summa were to buy out somewhere else she worked. And the other, I think, was regarding subrogation, regarding some long-term disability. Attorney Kuzma does respond, those revisions look good on our end. And then he indicates a little further down, thanks, Tim, I'll send this out to Ms. Bender right away. So send it out to her, review the rest of the document. She never signed, that's when the issue came up. So I don't look at his response of these revisions look good as we agree to the entirety of this document. He was going to send it to the client for a review, which he did. And this issue came up regarding her desire to bring a separate personal injury lawsuit. So I think the court properly determined that at the mediation, there was not a meeting of the minds as to all of these terms. The mediation was a general, yes, Your Honor.
Counsel, I'm sorry, I didn't mean to interrupt, but on that issue then, the court properly determined that there was no meeting of the minds. I am confused about that portion of the court's order that it seems to be conditional. Okay, there's no meeting of the minds here, but we'll put this case where there is no meeting of the minds back on the docket and enforce the settlement agreement if this PI case isn't filed. I mean, if there's no meeting of the minds, there's no meeting of the minds. I don't understand how this conditionality can work either way.
Yeah,
your side or the other side.
Yes, that's an interesting point. I would say this. I mean, I understand the question. I don't know at this point, since that suit was filed, the judge imposed that deadline. If you're going to do this, if you're going to pursue this separate cause of action by October 16th, that was done. I don't know at this point how that affects the, I guess, the status of whether or not there was a meeting. I mean, I think the court did find there was not a meeting of the minds. Whether that condition of now you got essentially 2 weeks to file this lawsuit, whether that was proper or not, I don't know.
But for purposes of appellate review, as your opposing counsel pointed out, we have nothing in the record to show that that personal injury case was filed. Or do you think there is something somewhere?
No, I don't think there is anything officially in this record on appeal.
Okay, I don't want to interrupt your flow. You can go ahead with your other.
I would acknowledge that. There's nothing in the record. I think I referenced it in our brief that it was filed, but that's the extent of it. So the The trial court, I think, made the determination that there was not a meeting of the minds based on the fact that essentially, there was an agreement to settle the workers' comp case. That paperwork was signed and submitted. The check ultimately was not cashed because of this issue of not coming to an agreement as to that global release.
Counsel,
Yes.
in what form is the evidence in the record that the parties did not have a meeting of the minds? What are we going to see that is going to show us what the trial court based that decision on?
Well, I think you have the transcript of the hearing the court conducted, and her decision that there was not a meeting of the minds based on that hearing and the evidence that was presented in the motions prior to that hearing as well.
Well,
And
on
there
that
was-
same, oh, go ahead, go on.
No, you go ahead. Go ahead.
On that same question, did Ms. Bender testify at the hearing?
She did not. Her attorneys both talked. They both were heard at that hearing, I should say. So Jennifer Lothar from my office, who we represented her on the workers' comp portion, then Attorney Meeker, who was representing her on the personal injury portion of her case. Her attorney spoke, but she personally did not.
Which of those two attorneys was part of the mediation?
That would have been my office. Attorney Meeker was not involved in the mediation.
But Attorney Lothar was.
Actually, I thought it was Attorney Kuzma from my office, but it was Nager Romaine Schneiberg represented her at the mediation.
So in your office or not in your office?
In my office, yeah.
Okay, thank you.
Yes. And so, was there another question?
Well, that was pretty much the question I was going to ask,
Okay.
except for I have one additional follow-up. When you said the transcript and then have clarified that Ms. Bender did not testify, was anyone put under oath and testified regarding whether or not there was a meeting of the minds?
I don't believe anyone was put under oath, Your Honor. I would just point out that they're all attorneys and all officers of the court are obligated to tell the truth at a hearing in front of a judge. But I don't believe there was any sworn testimony, anyone put under oath, to my recollection.
Thank you.
Yes, thank you. So with respect to, I'll then draw back to the other issue about whether the court properly vacated without a motion. I would just say this. I mean, at this point, I believe the court properly found no meeting of the minds. If a formal motion is required before the court can vacate the earlier entries from May and June of 2020, that can be done. Just, it could be remanded. We could file a motion to vacate based on the court's own finding on the record that there was not a meeting of the minds. I think the court took the next logical step and said, we don't have a meeting of the minds. Without a meeting of the minds, we can't settle the workers' comp claim only. And I think that's where some of the confusion came in as to the court indicating by agreement, because there was an agreement that if we don't have a global settlement, if we don't have a full agreement, then the parties do not have an agreement just to settle the workers' comp portion of this case. That Summa was not in agreement with that. I think that's for some of that kind of confusion over whether or not there was an agreement came in, at least from my read of this. So if a remand would be appropriate to say we need a formal motion asking the court based on the court's own finding that there was no meeting of the minds, I wouldn't see that as a problem or as an issue. And if there are no other questions, that's all I have in terms of oral argument.
Seeing none. Judge Carr?
No, I'm fine.
All right. Thank you.
Thank you.
Mr. Markova, you have 5 minutes rebuttal at your disposal.
Thank you, Your Honor. I just want to address a couple of points raised by the questions to Mr. Falvey. The first point I think that is has to be understood is that the October 4th judgment entry that was appealed had two parts, and only one of those parts was conditional. The first part was the judgments made in May and June are vacated. That was unconditional. Then there was a part that said, if a case is filed by a certain date, then, and so on. I don't think that those two parts, that part I will agree was conditional, but I don't think that the first part, which creates a final appealable order, vacating a final judgment, was conditional in this case. So I believe this court does have a jurisdiction over a final order under 250502.
Regarding that point, so counsel, I'm sorry for interrupting, but regarding that point, so what you're saying is the only part of the order that was conditional with a motion to enforce settlement. She
Yes.
vacated everything, but then she said, if you don't do it, if you don't file your suit, then I will
Enforce the settlement agreement.
Enforce
Yes.
the settlement agreement. So she vacates and then says, I'll enforce the settlement agreement if this doesn't happen. So that is what your argument is. The motion to enforce settlement agreement is the only thing that has any conditions on it.
That's my understanding of the October 4th order, Your Honor. Yes.
Okay, thank you.
The second point I wanted to address was at the October 2nd hearing, the only, I know we're on Zoom, I will resist making air quotes, evidence or information upon which the court could have predicated a finding that there was not a meeting of the minds were statements made by Mr. Meeker. I'd ask the court to look at the trial court's docket, the record of proceedings in this case. Mr. Meeker was not involved in any of the settlement proceedings. He did not even enter an appearance as counsel in the trial court case until September 28th, 2020. He certainly was a complete stranger to this case in June 2020, when on June 12th, a full and final settlement was entered into. Therefore, there was no evidence to oppose the evidence which was in the case that a final agreement had been reached. That evidence was the emails. And Your Honor, if you look at the transcript of the October 2nd hearing, right at the outset at page 5, I made the offer to authenticate those emails so that they would be properly in evidence. The trial court said authentication is not an issue here. I don't hear anybody objecting to those emails being authentic, and no one raised a question about that. So I believe, Your Honors, that what is in the record are those emails demonstrating a full and final agreement had been reached, and there is nothing to authenticate. Again, Your Honors, this case is pretty straightforward. The trial court lacked the authority to enter its judgment vacating the final dismissal of the workers' comp case with prejudice. The trial court also, whether you want to call it conditional or whether you want to, as we pointed out, simply note that there was no ruling definitively one way or the other on the motion to enforce the settlement agreement, which therefore under the law constitutes a denial of that motion. There was reversible error on that. We'd ask that the trial court be reversed on both of those points. This matter be remanded to the trial court with an order to enforce the settlement, reinstate the final judgments of dismissal with prejudice, and hold a hearing on the attorney's fees. Thank you, Your Honors.
Thank you both for your arguments today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website.